Welcome again. My name is Gisela Ayala and I am your professor on Introduction to Trademark Law. In this video, we'll talk about distinctiveness. Distinctiveness is at the cornerstone of trademark law because we need to protect trademarks that are distinctive and have the ability to distinguish products or services in the market. This is part of the foundations of trademark law, and it's so important that there have been many cases and discussions about it. Sometimes it is not clear if a trademark is distinctive enough to be entitled to protection. Now, distinctiveness is also important because when it comes to trademark infringement cases, the first consideration that a court makes is this a trademark protectable or it is not protectable? And distinctiveness is not a black and white concept. We will distinguish between two types of distinctiveness. There are those trademarks that are inherently distinctive, and there are other trademarks which are not inherently distinctive, not at first glance, but which may develop distinctiveness. That's why we differentiate between inherently distinctive concepts or trademarks and trademarks that have acquired distinctiveness. Now, as I said, this is not black and white, this is a spectrum, and the cases we will review will show you what's the court's analysis, what has been the court's analysis when it comes to this concept. So if we think about inherently distinctive trademarks, the most strong trademarks, we'll think about trademarks that are fanciful, arbitrary, or suggestive. And when we use the concept of acquired distinctiveness or secondary meaning, which we will also explore in this course, we'll mainly think about descriptive marks. Like I say, this is a spectrum, and we will think about these trademarks from generic trademarks, which are not protectable, and all the way to trademarks that are fanciful or arbitrary and on the strongest trademarks. So as you can see here on the screen, we have trademarks that are generic. These are trademarks that cannot be protected. Generic trademarks are those who refer to the genus, a broad category of services or goods, which are terms that are actually necessary for the market to describe the goods, and that even if together with others, we will see in some cases, cannot be protected under trademark law. Then we have a second type of trademarks that might be protected in certain circumstances, and these are descriptive terms. When we think about descriptive trademarks, we're thinking about a trademark that gives some information to the consumer. There are some trademarks that, because they are descriptive, they cannot be protected, and there are other trademarks that after some efforts, a lot of effort by market participants, by trademark owners, they may develop a secondary meaning. And then we have also suggestive trademarks, which give some information to the consumer, but they also require some degree of imagination to know what the goods are, what the services are, and these are entitled to protection. And most of the time, there is no requisite to prove a secondary meaning or acquire distinctiveness. And then we have arbitrary trademarks, which are words that have been taken from one context or industry and used on another industry when they don't have a meaning. For instance, Apple, for Apple computers or in general Apple devices and technologies. And finally, fanciful trademarks. These are the strongest trademarks. These are made up words, invented words, blended words that have been used to identify goods or services and which do not exist, are not in the dictionary, are the most entitled to protection under trademark law. Now, let's review some cases that have developed these concepts of distinctiveness and the spectrum of what we understand it's a good trademark from another that is not protectable. The first case is Abercrombie and Fitch v. Hunting World, Inc. And this case is important because it's one of those cases when the court clearly distinguished the spectrum of protection when it comes to distinctivity and explain what I have already told you, what kind of trademarks we can find in terms of their categories and in terms of their distinctivity. Generic, descriptive, suggestive, fanciful and arbitrary. Now, the court looked here at different trademarks, but especially focused its attention on Safari. The first thing that the court explained is that trademark analysis cannot be done in the abstract. It is actually a context-specific analysis. And a word like Safari may have a meaning in one context, but may have other meanings in other contexts. In that sense, the court explained that the word safari, first of all, referred to activities of exploration or hunting in East Africa. And in that context, of course, the word safari was generic and descriptive in many others. However, the court also recognized that the same word put in another context could have a secondary meaning or result totally arbitrary. Now, the court did not stop there. The court also gave an example. The court said, ivory, for instance, is descriptive when used for products made of the tusk of elephants, but arbitrary as applied to soap. So what I want to show you here in this first case, when, of course, the court makes this analysis of what kind of trademarks we can find in terms of distinctivity, is that the court also explained that the analysis of a trademark and the strength of a trademark is context and facts specific. A term may have significance in one context, may be generic in that context, but it may be arbitrary in another context. Specifically, the court explained, safari is a word commonly used and understood by the public to mean and to refer to a journey or expedition, especially for hunting, exploring in East Africa, and to the hunters, guides, men, animals, and equipment formed such as expedition. However, the court also stated that the word safari could have a different meaning in other contexts, and the court said, safari as applied to ice chests, tents, and smoking tobacco is not descriptive. It refers or conveys a sense of high style and attractive allusion to consumers of the plaintiff. However, the court also stated that the same word had changed over time and it had acquired certain meaning for certain public or consumer. The court said, in this case, safari is not descriptive for certain goods like smoking tobacco or tents. However, it is in some way descriptive or generic when in the context of clothing. The term has become a part of a family of generic terms within the language referring to contemporary American fashion apparel. Here, the court gave different examples like the safari hat, safari jacket, safari suit, among others. So that was our first case where the court explored the spectrum of distinctiveness and explained that there is always a context analysis required to determine whether a trademark is generic or not. In the next case, Saturains Inc. v. Oak Grove Smokehouse, the court explores not only the spectrum of distinctiveness, but also a product's specific and makes an analysis of the market and secondary meaning. So here, the court refers to product that is used to fry chicken and fry fish. The trademarks at issue, as you can see in the screen, were in some way telling the consumer what was the purpose of the trademark, fish fry. Of course, we have a trademark word that is separated. It's in two parts and separated by a dash. We have chick fry, which is not exactly telling the consumer what the product it's used for, and the defendant's mark, which are fish fry, two words, and chicken fry. Now, in this case, the court analyzed all the terms, but I want to highlight that, for instance, in the case of fish fry, the court made two different conclusions. The court said that for certain goods and certain markets, the expression or word fish fry was the descriptive term identifying the function of the product being sold. In that sense, it was not protectable under trademark law. And the plaintiff did not offer enough evidence of a secondary meaning or acquired distinctiveness. However, the court also referred to a prior decision in the case where the court of first instance decided that This term, fish fry, had secondary meaning in certain markets. For instance, the court made specific reference to New Orleans, where Saturnines had demonstrated that fish fry had acquired a different meaning in the mind of the consumer. Now, the court developed a specific steps to get to this conclusion, and this is important to look. First, the court look, okay, what kind of trademark is this? Is it a logo? Is it not a logo? It's a word mark. Second, the court applied what I call a conceptual test. The court looked into the dictionary meaning of the words. Now, this is just one part of the analysis to determine if a trademark is generic or descriptive. We can look at the general meaning of a word, dictionary meaning, but we can also look to the meaning in the specific industry, the meaning of that word for the plaintiff, and the meaning of that word for the public in general. Not what the dictionary says, but what in reality a consumer will probably understand when seeing a word or term in the market. So that conceptual test was also applied by the court. And then the court applied what is called the imagination test. And here the court wanted to identify what was that relationship between the concept, in this case, fish fry, chick fry, fried chicken, and the consumer that was targeting this plaintiff and the defendant. The idea was then to determine if there was some acquired distinctiveness in any of these terms. After that, the court said it's also important to consider what I call a market needs test. We want to determine if a competitor will need that term in the market, maybe to describe the product or to sell it, to explain it. And also we want to consider if there have been efforts to use that term before, maybe marketing efforts, maybe it has been used in the media to explain products that are similar. So after doing this, looking to the mark, doing a conceptual test, what the meaning of those words is, an imagination test, what's the relationship between the actual words of the mark and the product as applied there and the consumer, and then applying a market needs test to know if competitors or the market in general need those words. The court concluded. So if the term requires certain imagination or thought process to make a conclusion regarding the goods or the products, the term is suggestive, and then it's entitled to protection. However, if standing alone, the word conveys information or characteristics about the goods or the services, it is a descriptive word and most of the time not protectable under trademark law. In this case, then, the court also explained that even if a term is descriptive and has acquired a secondary meaning, that does not mean that the trademark owner has a monopoly over the non-trademark use of that term. Basically, the court said, when the allegedly infringing term is used fairly and in good faith only to describe to users the goods or services, that use is fair. It's a fair use and therefore is not unlawful. So even if we have a trademark that is descriptive and has a secondary meaning and is entitled to protection, that descriptive use of that term in the market cannot be monopolized. So even if you have the right to use a trademark that is descriptive but has secondary meaning, you still have to permit the market and competitors to use the term, maybe to explain the goods or to sell those goods in a non-trademark manner. The court actually said, the holder of a protectable descriptive mark has no legal claim to an exclusive right in the primary descriptive meaning of the term. Consequently, anyone is free to use the term in its primary descriptive sense so long as such use does not lead to consumer confusion as to the source of the goods or services. So here again, we see how the purposes of trademark law have a role in the analysis of whether a trademark is or not protected under the law. The court considered what's the meaning of these words, what's the connection between the trademark and the product and the consumer, but also what's the purpose of trademark law, and it's to avoid confusion and deception in the market. So as long as a descriptive term is used in a non-trademark manner, it might be also used by non-trademark holders. And again, the court explained that there is a spectrum of distinctiveness and the different categories are organized ascending, showing how low sometimes the protection is and how strong it can be, depending on the word or term we are looking at. Now, in this case, the court also explained that a descriptive term may acquire secondary meaning, but this is not an automatic process. The plaintiff or the person who wants to demonstrate secondary meaning must be able to show by media, marketing efforts, volumes of sales, maybe the intent of others to copy their trademark, the length of use of the trademark in the market, survey as to consumers' impression that that term, in fact, has acquired secondary meaning. So in order to prove that a descriptive term, and we're going to look in more detail, has acquired a secondary meaning in the market, we have to prove a group of strong evidence. One piece of evidence alone will probably not be enough. That's why the court explained. Descriptive terms are not protectable by trademark absent a showing of secondary meaning in the minds of the consumer public. In assessing a claim of secondary meaning, the majority in the consumer's attitude toward the mark must denote to the consumer a single thing coming from the source. So basically, the idea here is that secondary meaning must be reflected in the market, in how the consumer connects certain goods to the producer, to certain characteristics, high quality standards. That's why we need all these different kinds of evidence, again, like volumes of sales, service, marketing efforts, media presence, the length of the use of the term, among others. Now, the court observed, for instance, when it comes to this non-exclusive use of the term for non-trademark purposes, Oak consciously package and label their products in such a way as to minimize any potential confusion in the minds of consumers. The dissimilar trade dress of these products prompt the district court to observe that confusion as to the point of purchase, the grocery shelves would virtually be impossible. There will be no confusion. So I want also point out here that the case looked to the term, look to the meaning, look to the situation regarding the imagination required to figure out what the goods are, this imagination test, look to the market needs these words or not, but the court also look at the specific conduct of the defendant. How is the defendant presenting its own product? It's a fact-specific analysis and requires the looking into different elements. And finally, we have Filipino Yellow Pages versus Asia Journal publications. Now, this case also talks about generic terms, descriptive terms, and the strength of trademarks. But what I want to highlight from this specific case is first, the plaintiff had an application for trademark protection. However, at the time of the litigation, that trademark application was not completed. The plaintiff highlighted that a trademark that is registered is entitled to a presumption of validity. And that in this case, even though the terms independently considered were generic, when together, they were not generic anymore and were entitled to protection. However, the court explained the meaning of those words independently, and then also explained that the fact that you have combined two generic terms does not make the composite words something unique or different that can distinguish products or services in the market. Basically, the court explained, a combination of two generic words also is generic unless a combination is a deviation of natural use. However, when the court says a deviation from a natural use, what the court is saying is basically that if you take two generic terms out of context, out of its natural context, where those words are generic, and you use them in a market, in an industry where they are not generic anymore, of course, you may have a protectable trademark. But again, this is fact specific and context specific. And in this case, we were talking about a specific product directory where you can find directions and information about different businesses. So in this context, even if the words Filipino and Yellow Pages have been together, this did not result in a protectable trademark. So as you can see here, when we think about distinctiveness, we have a spectrum of different trademarks. We already have explained what generic trademarks are, which describe a broad group of goods or services, and they are not entitled to protection. We also discussed what descriptive marks are, marks that give some information about the product and may be protected if they acquire secondary meaning. That's a concept that we will explore more in the next video. Then we saw that there are suggestive trademarks that give some information to the consumer, but they also require imagination. And then we have arbitrary trademarks, which are words or symbols that are generic in one industry, but they are placed in another industry on another context where they result unique and they are able to actually distinguish products or services in the market. And finally, fanciful trademarks, which are made up words, invented words, which have no dictionary meaning and are the strongest of all trademarks in the spectrum of distinctiveness. In the next video, we will explore the concept of secondary meaning. And again, remember to review your materials, do your quizzes, and ask questions, leaving in the comments.